In this video, we would like to discuss the very advantages of tribunal system and so also the advantages of tribunal system. So the first advantage of tribunal system falls under as philosophy of welfare, modern welfare state is developed throughout the world. So it increases the very activities of government and those activities of government relating to health, education, old age, pension, and employees and workers benefit and welfare. So also other welfare activities. So it created also several new problems, and as it would be left to the court, then it will be overburdened. So there also the possibility delay in disposal of such cases. So it will slow down the very process of welfare schemes or measures or programs taken under the modern welfare state by the government. So to decrease those problems, and for that the administrative adjudication is required which will solve such burdens or overburdening of the court, and it will also speed up the very implementation of welfare schemes and measures and programs in various fields such as education, health, shelter, old age pension, and also the very employees and workers' benefits and welfare who are associated with industries, factories, etc. And beside the first one, the second advantage of tribunal system is quick justice. So, as the tribunals are not bound by the procedure such as provided under the Civil Procedure Code or as provided under Indian Evidence Act, and regarding that also there is no need of technical and rigid procedures as followed in usual ordinary civil courts. So their procedures are very simple and pragmatic in nature. So the tribunals will settle issues quickly, and those settlement of such problems or issues like tax or issues between employers and employees are the very examples that how quick justice could be delivered through administrative tribunals, and that is one of the major advantages of tribunal justice system. And the third one, that is administrative adjudication, is always cheap and less expensive as the usual civil courts or the ordinary courts of the land. They followed lengthy procedure, and so also it burdened all the plaintiffs and the petitioners. So, in that sense, as the administrative adjudication is quicker and speed, so it is both cheap and less expensive rather than following the very usual procedure followed in the civil court or the ordinary court of the land. So also another advantage of tribunal system is that it creates or as it consists persons having special experience and training in such particular fields as, for example, the very knowledge in particular subjects or specialization or specialized knowledge in the field of accountancy, tax, labor, education, health, etc. So, the very process of administration, adjudication is more cheap, expensive, so also it leads to quick and speedy justice. And the fifth one regarding policy consideration. So, as it is considering the matters of public interest and such issues arising from the modern welfare state and regarding the very public policy made by the state or the government. So, in that sense, the administrative tribunals they delivered quick and speedy justice, so also they determine such public issues which are involved with public interest. And as to the very definition and advantages given by Professor Wade and Phillips in their work, that modern government give rise to many disputes which cannot appropriately be solved by applying objective legal principles or standards and depend ultimately on what is desirable in public interest as a matter of social policy. So also, Professor Robson summed up the merits of administrative tribunals such as they discharge their functions more rapidly, more cheaply, more efficiently than ordinary courts, possess greater technical knowledge and fewer prejudices against the government, give greater lead to social interest involved, decide disputes with conscious effort at furthering social policy embodied in the specific legislations enacted by the legislature or the state or the government, and regarding the very disadvantages of tribunal justice system or the administrative tribunals. The first one, the first disadvantages relating to this is no uniformity in composition and procedure. They are as not bound by Civil Procedure Code and Evidence Act, so they are only bound by the provisions of the specific statute which created and constituted and established such tribunal. So their functioning and growth is haphazard as there are numerous tribunals on numerous subjects and there would be conflict in their functioning and in their very growth. And the second important disadvantage relating to tribunal justice system is that no uniformity in the matter of appeal against the decision of the tribunals, as different statutes provides different types of appeal, sometime for reference and sometime appeal on matters of law or against the very decision of the tribunal. And the third most important disadvantage of administrative tribunal or tribunal justice system, as there is no legal experts, as they are not legal experts and they don't have legal qualifications as required in courts. Judges and lawyers are trained in law, while in tribunal the judges and lawyers are not so trained in law. So the decision of courts are superior in comparison to those decisions given by the tribunals or those decisions or decrees or judgments delivered under the tribunal justice system. And the fourth disadvantage associated with administrative tribunal is departmental bias, which is an inherent defect found in tribunal justice system, as members are not so independent as judges of ordinary courts. So there we found departmental bias in tribunal justice system. And the fifth disadvantages, according to Professor Robson, there is lack of publicity of the decisions, which is an important demerit. Even if published or given abbreviated form and not in detail. So this is another most important demerit of tribunal justice system as mentioned by Professor Robson. And the sixth one, that is the lack of proper cross-examination as we found in ordinary courts or civil courts. And there is also poor quality of the investigation into the very question of fact. So it becomes very difficult to get or to arrive at the truth, as there is no proper cross-examination and poor quality of investigation into the very question of fact. So it becomes very difficult to arrive at the truth or to get the truth. And in that connection, we will discuss certain administrative tribunals such as tax appellate tribunal, which has been empowered to make rules to meet its own. So also the copyright board, which is another tribunal bound to follow the rules and procedure formed under the Copyright Act. There is a great need to introduce uniformity and regularity in the procedure of the tribunals. Justice demands laying down of the minimum standard of the working of administrative tribunals. A legislation should be made to achieve this very objective. And now we'll discuss the very creation of certain tribunals under specific statute or legislations enacted by the legislature, and such as the industrial tribunals, as we found under the Industrial Dispute Act 1947, the Railways Rates Tribunal, as constituted under Indian Railways Act 1890, and administrative tribunals as constituted under Administrative Tribunal Act 1985. So also, as per the very provisions of Article 323A regarding service matters, such as the Central Administrative Tribunal or the state administrative tribunals shall so as per the provisions of Article 323b for creating tribunals regarding other matters such as already we have discussed regarding the income tax appellate tribunal, industrial tribunal, then the railway rates tribunal, the labor tribunal, etc. And there are certain statutory domestic tribunals created under the statute such as the Bar Council under the Advocates Act 1961, the Medical Councils under the Medical Council Act 1956. So tribunals have the power to issue directive, order or writ under Article 226 and 227 as provided under the Constitution of India with respect to only service matter and appeal against the decision of the tribunal may one move to Supreme Court under Article 136 of the Constitution. So these are the very advantages and disadvantages relating to administrative tribunal or tribunal justice system and the various tribunals created under various statutes and the very power of the tribunals as provided under Article 226 and 227 of the Constitution, confining it to only service matters, then the very provisions regarding appeal against the very decisions of the tribunal as provided under Article 136 of the Constitution, where the appeals lie before the apex court or the Supreme Court of India.